of foreclosure.
Well, here in California, I think we never even thought about short sales because property went up and up
It was
and
always
up.
going up, yeah.
Everybody just assumed it was always going to go up, so there wasn't this problem with property values going down and mortgages being greater than the amount of the value of the property. But the idea of a short sale in real estate now is if you have a property, and again I'm talking residential property, you could do this with commercial as well, but residential is what we're talking about. And if again the property value is less than the amount of the mortgage, then you can try to structure a short sale by, first of all, finding a buyer who's willing to buy your property for some amount of money that they're willing to actually offer. And then you take that to the lender and you try to get the lender to agree to take the amount that the buyer is willing to pay for the property, the net proceeds of that sale, as the payment of the mortgage. Mm-hmm. And again, you would want to work out the details of that so that if there was a deficiency, which there would be in a short sale, you would try to work it out so that you didn't have a lender who was going to come after the borrower after the sale closed for that deficiency amount. Mm-hmm. So you need to have an agreement with your lender that they'll accept the proceeds of the sale mm-hmm. as the payment of the mortgage.
Okay. So
before we leave the topic of short sale, I don't know where we're going next, but there has been new legislation.
Basically, that's the next thing I was going to raise, but go ahead if you like.
Yeah, the new legislation, which came into effect July 15th of this year.
Yes, this is 2011, folks, yes. So we'll be broadcasting next year in 2012. But
2011, July 15th, 2011, there was a new California statute.
Yes.
And what it was intended to do was to solve the problem, again, of the multiple mortgages, because people would have a property that they would want to short sale. And they would go and they would talk to the holder of the first, and they would get agreement to sell the property and to have that lender accept the proceeds. But then the holder of the home equity line of credit or the second or third or whatever mortgage it was, since they weren't going to get any money when this transaction closed, you still would have to try to get their agreement, and there was no reason for them to agree. So this was causing difficulty in getting short sales to actually happen. And people were having to do things like offer money to the holders of these notes in order to get them to agree to the short sale. So because this was holding up short sale process and the legislature wanted to encourage the process, they passed this law that said, no, if you get the lenders to agree to the short sale, then none of them can come after you for a deficiency judgment. So it wasn't just the first mortgage, it was any other mortgage. But it's any other lender or mortgage holder that agrees. Mm-hmm. So this is one of those unintended consequences sort of things that could create even more problems, because now the question is, why would these other mortgage holders agree to mm-hmm. the short sale? Well, part of the statute says they also cannot demand anything from the borrower in order to get the short sale to close. So instead of asking you to pay them $10,000 or $20,000 for their agreement, they can't do that under the statute. So now their option is to say nothing, but also they don't have
agree. Yeah.
They don't have to agree.
Yeah.
But unfortunately, and I shouldn't say unfortunately, the fact is that it doesn't prevent the borrower from offering to pay something. So it sort of just turned the tables a little bit, where if they won't agree, you can say, okay, I will offer you money to close the short sale, and either that or the short sales. I think there's a fear that short sales may not happen very much under this new statute, because there's no incentive if you have more than one mortgage, at least, that there's no incentive for those.
Well, they still seem to be happening. I'm still talking to people. They're still negotiating. Of course, it takes an awful long time in any case to get one of these things through, and so we'll have to see. But like you said, now there are disincentives. And in a sense, we're sort of handing more power to the junior mortgage holders by saying, right, I'm not going to approve this thing.
Right. Part of the reason, keep in mind, Michael, is if they let it go into foreclosure instead of agreeing to the short sale, and they're a second or a third, they have a right to pursue a deficiency, because only the first is satisfied. So again, why would they agree to it? Well, maybe they will. I'm not saying it won't happen, but there are going to be situations where they won't, and then
they're stuck. Okay. So maybe you should just sort of review this again for just a moment. So just as a comparison for the short sale as opposed to the trustee sale, what is the consequence for the principal mortgage holder and as opposed to these junior mortgage holders?
Well, I think if you could do the short sale under the present law, it would be better in many ways. You can control the timing better, you can control the sales price better, so you have more control over foreclosures. Can take a very long time as well, and you have no control.
Yeah.
But also, the new short sale law doesn't apply to just occupied premises or purchase money kind of mortgages. It applies to rental properties. Mm-hmm. So it's a better situation for the borrower if they can use the short sale and get the agreement of the lenders. It's a much better system than the foreclosure. The foreclosure part, the trustee sale, if you have a first mortgage and they agree to either it's non-recourse financing, so they can't pursue a deficiency, or they do the trustee sale, they can't pursue a deficiency. It's clean as far as the transaction is concerned. You don't have any deficiency to worry about. But in the situation where you have these other mortgages, then you still have to either get them to agree to something, or you have the danger that they'll pursue you for the deficiency.
Okay. So I'm a little concerned about time, so I'm just going to keep moving ahead here. I have to leave out some details. Now, is a foreclosure or a short sale of an investment property different from that for a residence or a vacation home?
The trustee sale, the anti-deficiency statute of California, we haven't talked about non-recourse versus recourse debt. In California, we have what's called an anti-deficiency statute. So certain properties qualify under that statute to, if they're taken for less than the value of the mortgage, there is no recourse. That doesn't apply to investment properties. It doesn't apply to rental properties, because you have to have a residence that's occupied by the borrower. So residences are special in that sense. Vacation homes also don't realize the same kind of protections under the statutory laws as a personal residence, a residence that's occupied by the borrower.
It does?
It does not.
It does not. Okay. Right. So in other words, unless it is your residence.
Unless, again, it's a short sale under the new statute. See, this is why this has all gotten a lot more complicated.
Yes,
because any of these things, if you do the short sale procedure, it shouldn't really matter as long as you get the agreement.
So, and this is the new deal here in California, so I don't know what's happening in the other states. Okay, so how about then this business of what is a recourse debt, what is a non-recourse debt, how do you tell the difference?
Well, in the residential context, you really can't tell the difference by looking at anything, because you could look for many years for a note that was written in non-recourse terms and you wouldn't find it in a residential mortgage in California. Mm-hmm. It's not technically non-recourse financing. What it is there are certain types of properties and certain type of buyers that qualify under the anti-deficiency statute, which results in the mortgage being non-recourse. So non-recourse financing is when you have purchase money for a property of 4 or fewer dwelling units occupied by the buyer. That qualifies under the anti-deficiency statute, and therefore we call it non-recourse. If you refinance that property afterwards, after you buy it, you convert the non-recourse type of financing into recourse financing. If you buy a rental property, because it's not owner-occupied, it's not considered to be non-recourse financing.
Okay. So you can't tell by looking at the mortgage. There's no special language.
No, it's the circumstances.
It's the circumstances. And so makes it complicated. But again, it's the original acquisition indebtedness is what we're talking about here. That can be non-recourse. And then once you refinance, it's going to become recourse. Now, are these rules for recourse and non-recourse debt consistent among the states?
No. As I said, not all states even have anti-deficiency statutes. And not all states have the trustee sale procedure for the method of foreclosing. So the state laws are really quite different, and in some cases dramatically different in terms of how this works and whether you have recourse or you don't have recourse. In other words, if a loan says non-recourse, it doesn't matter what state it's in. But if you're dealing with an anti-deficiency statute, if that's what you mean by non-recourse, then that's going to change very, varying from state to state.
Right. So you can't just rely on us talking here about this California stuff, and
No, and that's
as I
also
said before,
also the reason you can't really rely on the internet, because an awful lot of stories that people tell are based on different locations.
their particular state. How about these changes in the law? So, as we said, I mean, we've got an extension of this anti-deficiency statute to short sales, as we've said. Do you think that is going to make these into non-recourse loans?
Well,
If you had a refinancing again, okay.
in effect, yeah. In effect, what it is an extension of an anti-deficiency statute to short sales.
Yeah.
And so again, it depends on how it happens, and you have to get agreement from your lenders and all of that. But you can create an anti-deficiency type of a situation in a short sale.
I guess what my point is, and you and I talked about this a little bit before. So, and it's that, as we understand it, again, it's not non-recourse at the time before the short sale agreement is made, because the lender has to agree.
Right.
And so it's still recourse. It's still going to be a recourse loan. And this is really important, folks, when we get into the tax considerations.
Right. I wasn't speaking about
Yeah.
tax problems
Yeah.
or situations, but that would be a difference in the tax
Okay.
situation.
Bill, we just have a couple of minutes left. When should you consider filing for bankruptcy?
Well, not everybody qualifies for bankruptcy. I
Right.
think if you have one of these distressed property situations, what I tell my clients is they should at least consult with a bankruptcy attorney and get the information. That's far from filing bankruptcy, but there's nothing wrong with understanding what your options are. And bankruptcy will stop a foreclosure. So if you qualify for bankruptcy and you're in foreclosure and you can't stop it, you could file the bankruptcy and it would stop. It may not permanently stop it, but it would definitely stop it, at least temporarily. And sometimes in bankruptcy you can actually discharge some of these obligations. So there is a benefit to bankruptcy. There are obviously a lot of downsides to bankruptcy, and that's not something that you want to do,
Lightly.
quickly.
Yeah.
But you should, if you're going to think about these things, and if you haven't been able to structure something that works, and it looks like you're going to be going into foreclosure, you should at least discuss it with a bankruptcy attorney and find out what your options
Yeah.
might be.
If you see our tax program, there's some definite tax advantages to bankruptcy. Again, the problem is that your credit is probably going to be screwed for, I guess, about 7 years. So.
Yeah. I should, I guess, mention that anything that happens in this context, any non-conforming payoff of an obligation, is going to have an impact on your credit rating, and it's just a question of how much and for how long. But everything does. You hear things about short sales being better for that, and they can be. But for everybody, there's a consequence to their credit rating.
Right. Okay, folks. Well, this is a huge area, and so we hope we've given you a good introduction, some things to think about, and to have a conversation again with your own legal counsel and tax advisor about. And so I think we're going to leave it at that, and we'll see you next time on Financial Insider Weekly.